And a school shooting in Nevada has raised an interesting question. Should the parents of the students be held liable for their child getting their hands on a gun? Joining us now is Dallas criminal defense attorney John Teakell. John, thanks for joining us. If this case were in Texas, where a child gets a hold of their parent's gun and commits a crime, what would happen?
Well, there actually is a statute in Texas that does make a person liable, or can make a person liable criminally, if they make a firearm accessible to a child. And, of course, in Texas, like a lot of places, it's not uncommon for people to go hunt or shoot with their parents or an adult. So there are exceptions to that, but actually, if you make a firearm accessible to a child, theoretically and technically you're violating the law. Now, when they say accessible, there's some definitions. It just basically means if you fail to secure it. In other words, the statute reads that if you fail to secure the firearm, or if it's left in a place where you knew or should have known that the child would gain access. So secure just means make it where it's not going to be dischargeable or not even an accessible period, or at least not dischargeable.
I mean, obviously, we all know if you left it on the coffee table or under your pillow and your 12-year-old got it out, then you probably could be facing some problems. But if you had it in a lockbox, and what if your child figured out the combination and got into it, and are you still liable?
Well, that's where it gets into more gray area. It appears to me that you probably would not be because
you've taken the steps necessary that you should have.
Exactly. It says readily dischargeable, to prevent it from being readily dischargeable. In other words, if you locked it up and they still got in somehow where they shouldn't have, or it would be difficult, I would think that a prosecutor's office would not charge you, or a grand jury would not indict you, or at least a jury would not find you guilty. Now, there's some exceptions to the firearm accessible to a child. In other words, if I think the statute basically reads that if the person is supervised by a person who's 18 years or older for sport shooting or hunting, or if someone broke into your house or trespassed and they obtained a firearm, or if a child actually was defending himself when somebody was breaking into the house.
Matt Stoker and I were just talking about that before we got you on the air. It was like, well, what happened if your 16-year-old came home from school, both parents are at work, someone breaks in the house, he gets the gun out and shoots? I doubt there would be a case. I don't assume anybody would go after this person, but, for the sake of argument, what would happen?
Well, the statute lists out about 4 different exceptions, and that's one of them. That is that if the child is actually defending his person or property. So, in other words, if he gets a firearm that shouldn't be readily accessible, or was made readily accessible, and it wasn't supposed to be per the statute, then it looks like that's an exception, and the person would not be charged or prosecuted.
We're talking to Dallas criminal defense attorney John Teakell. John, is it a good idea to go after these parents? I mean, is somebody just trying to hold somebody accountable?
I think that's it. I think it's it. It's obviously a tragic, sad situation, and that's something that could theoretically happen to just any gun owner if they fail to put it up as far as they should, or lock it, or what have you. Or if the child wanders too far or goes too far further than they normally do as far as trying to look for things or access things. But I think that's kind of the bottom line, what you just said. Because of what happened, they're wanting to hold someone liable, and that the natural person would be the parent.
What could the parents possibly be facing?
I don't know criminally what's going to happen there. I presume that there's a state statute there that's similar to the one in Texas, or somewhat similar.
Right.
I would imagine that they quite probably would be or could be prosecuted, or at least are investigated for it. Not knowing the exact statute, how it reads, I would imagine it's somewhat similar. Won't be surprised if they are charged, and then the attorney for them either comes to some sort of agreement or gets or goes forward to trial.
What could they face?
Well, I would imagine it's probably charged as a felony, So some sort of prison time, it may be 2 to 10 years. It may be something in that range, just depending on how that particular state does their penal code.
You know, as you said when we first started about gun owners, a lot of them here in Texas, obviously the important message is know the laws, but also make sure you have everything locked up and take every precaution that you possibly can.
Right. Yeah, and of course the exception is if you have an 18-year-old or older who's supervising. That's an exception to you being prosecuted under this statute. However, as just about everyone can imagine, you would probably feel better, of course, if you had a person who's older than 18 or 19 supervising a 13 or 14-year-old.
Makes sense. John, I appreciate you joining us for a few minutes. Thanks so much.
Sure, you bet. Thank you.
That's Dallas criminal defense attorney John Teakell. You can find out more at teakelllaw.com. That's TEAKE